Qualified immunity. We all talk about and see the negative effects and poor attitudes spawned by qualified immunity every single day, where authorities, specifically cops, don't have to worry about taking personal responsibility for abusing or even eliminating another human being. Newsweek recently reported that a respected Mississippi judge rebuked the Supreme Court for its definition of qualified immunity, stemming from a 2020 murder case, with one legal analyst saying that it's part of a public shift in the law's interpretation. Now, keep in mind, one of the biggest problems with qualified immunity is you can't find it written into any federal law or statute. The Civil Rights Act of 1871, now codified as 42 U.S.C. 1983, gave private parties a powerful vehicle to vindicate their constitutional rights against state and local government officials. But the Supreme Court over time has restricted its effectiveness with the doctrine of qualified immunity. This doctrine protects police officers no matter how egregious their conduct if the law they broke was not, quote, clearly established. Under this sky-high standard, anyone suing an officer today has to show that a virtually identical case occurred before the present case, which involved the same facts and the behavior was found unconstitutional. Not only that, strong cases against police officers often settle, meaning they never even get the chance to be considered as part of common law. So if you can't establish a legal precedent, there won't be any growing body of cases to draw from to defeat future abuse of power cases. No less than Supreme Court Justice Clarence Thomas has said that he has strong doubts about qualified immunity as a doctrine. And that's some pretty strong support for reform and shows what a mess this has become. Qualified immunity needs to be qualified, but today it's nearly absolute. Shoot first, ask questions later, and you won't even get in trouble for it. If our laws are to mean anything, the ones that police officers are sworn to uphold and protect, the public needs to know that misconduct will be punished regardless of whether you're a member of the public or a law enforcer. This article says, Carlton Reeves, a district judge in the Southern District of Mississippi, wrote an opinion published Monday that the qualified immunity doctrine was invented by the U.S. Supreme Court in 1967 and essentially means that people wronged by government agents cannot sue the agents unless the nation's highest court previously found, quote, substantially the same acts to be unconstitutional. But this judge says that the doctrine has come to be an unconstitutional error and that it's past time for the judiciary to correct this mistake. The only problem is the black-robed tyrants of the highest court in the land aren't in the habit of correcting mistakes. They're in the habit of making them. They're the reason we have Terry v. Ohio and Pennsylvania versus Mims. And it's this whole atmosphere where officer safety trumps unalienable rights in the minds of the tyrants. Judge Reeves wrote, "The court agrees with these calls for change. Congress's intent to protect citizens from government abuse cannot be overridden by judges who think they know better. As a doctrine that defies this basic principle, qualified immunity is an unconstitutional error." Think about it. Qualified immunity actually defies the First, Second, and Fourth Amendments on their face. He used the example of a 2020 homicide and the false accusation of a black man, Desmond Green, who was accused of capital murder and the shooting death of Nicholas Robertson in Jackson, Mississippi. Another man, Samuel Jennings, told law enforcement that Green was responsible for Robertson's death. Green was subsequently indicted by a grand jury, even though he denied the allegations and any role in Robertson's death. As Reeves noted, Green was detained in the Hinds County Detention Center and stayed in the inhumane facility while awaiting trial. Green claimed the jail was infested with rodents and snakes, that his cellmate was stabbed, that his food was moldy and stale, and that he often had to sleep on the cell floor while enduring constant yelling, violence, and fear. Samuel Jennings later recanted his story about Green's involvement in March 2022, telling public defenders that he was drug impaired when he made a baseless accusation that Green committed the murder. Green, who lost nearly 2 years of his life, sued the detective who locked him up, her employer, which was the city of Jackson, Mississippi, and the operator of the Hinds County Detention Center. The Mississippi judge, Reeves, says Green is now on the precipice of being wronged a third time, not by a rogue officer or jailer, but by the law itself. Because the detective says the legal doctrine of qualified immunity requires the court to dismiss Green's claims against her. This senior vice president for legal studies says that Judge Reeves' ruling dates to federal civil rights law following the Civil War. It's known as 42 U.S.C. 1983 and was enacted by Congress due to local government officials like sheriffs and constables participating in the oppression of newly freed blacks and wanted to provide a federal remedy for anybody, although blacks were the victims. Reeves, in his opinion, referred to it as the Ku Klux Klan Act. The insane and outlandish thing about the Civil Rights Act of 1871 is that when the 42nd United States Congress passed it and Ulysses S. Grant signed it into law, it gave the federal government even broader powers to, quote, guarantee citizens' constitutional rights. It gave the president the power to imprison people without a trial. And this is known as suspending the writ of habeas corpus, and to use the federal military on domestic soil to enforce constitutional rights. In other words, it suspended constitutional rights to protect constitutional rights? Does that make any sense to you? In 1967, the court created an exception that essentially provided law enforcement officials with qualified immunity or a get-out-of-trouble-free card to prevent them from being financially culpable in what could be deemed as frivolous lawsuits. The advent of qualified immunity was actually a two-step process, with the 1967 case Pearson versus Ray creating a so-called good faith standard, and then a 1982 case, Harlow versus Fitzgerald, expanding it to the current clearly established standard that requires plaintiffs to identify a nearly identical pre-existing case in order to defeat qualified immunity. And of course, these standards make it nearly impossible to defeat a corrupt cop in court. This legal expert explained that the court's ruling translated to individuals who are victims of purported crimes at the hands of government employees having to identify previous cases in their jurisdictions in which police violated rights in a seemingly identical way. If that case doesn't exist or is not factually similar, even though rights were violated or believed to have been, officials would get a free pass and the case would be dismissed. He called it a very broad law, and that would be an understatement. This legal analyst says, quote, qualified immunity has become an extremely controversial legal issue because it creates this defense out of whole cloth. Courts are not really supposed to make policy. They're supposed to rule on existing laws. He said the interpretation of the law also creates a tremendous amount of injustice. You think? Which Judge Reeves delves into in his 21-page opinion, saying in part that the government can imprison people for conduct they were unaware was illegal. This legal analyst called it a goose-gander problem in which ordinary citizens who are unaware of laws could go to prison, yet police officers who are trained about issues like probable cause and the Fourth Amendment are likely more aware of the legal repercussions. A high-rolling law professor wrote in a blog post that Reeves is one of the most eloquent and powerful critics of qualified immunity doctrine on the bench. Judge Reeves denies defendants, like cops, qualified immunity, concluding that they violated clearly established law. Yet he goes further, demonstrating why qualified immunity is unsupportable as a matter of history, text, and policy. Well, how about common sense and natural law? It's never going to be right for a man to violate another man. If qualified immunity is not granted to all, then it shouldn't be granted at all. Leave your thoughts about this in the comments below. If you like these videos, maybe you'll like some of my others, subscribe to this channel, hit the bell notification icon, like this video, and share this video. Grab a shirt, become a channel member, but more importantly, know what your rights are and fight for your rights. If you don't use your rights, if you don't flex those rights, you will lose them. I'll see you in the next video.